This is More Law on Fox 19.
Thanks for joining us for More Law this morning. Today's topic, divorce and child custody. And as always, we are taking your calls live on the air. It is not a pleasant subject, but you need to know what your rights are. There are many issues: how long a divorce takes, how child custody works, child support, the list goes on. If you have questions about divorce, custody, child support, or another family law issue, give us a call at 513-421-4691. Back with me today after a couple of weeks off, Don Moore, how are you?
I'm doing great. How you doing, Deb?
Welcome back, and I want you to tell people where you were because I'm so jealous.
We did a little Mediterranean cruise. It was a lot of fun. We got to Italy and Greece and Turkey.
And it snowed in Istanbul.
It did, and I ate my way all the way across the Mediterranean.
Well, that's not a bad way to go.
Yeah, well, now you pay. Hey, speaking of eating, we have a wonderful guest today.
I can't wait to hear how you're going to get from.
Oh,
okay.
this is an easy transition.
Okay.
Randy, welcome. Thanks for coming.
Thank you.
Randy is one of my favorite lawyers in town. She is, in addition to being one of the very best domestic relations lawyers, practicing for over 30 years, second generation, multi-generations like in our family. She is, in addition to being a super lawyer forever, she also has the Forkable Feast. She is a great chef. I shouldn't say cook, I should say chef,
Oh,
right?
Try hard.
All right, very good. And you're tied in. Tell us about the Forkable Feast for a second.
Forkable Feast is a food operation on Madison Road across from Crossroads Church. We have food prepared, ready for you to take out, take home for dinner, already cooked, ready to eat. And it's healthy and solid food like fish, chicken, and and we do catering, and we have like salads, sandwiches, all home cooked at home.
And delish.
Our kitchen.
And delish.
And delish, very delish.
Well, thanks for being here today.
Absolutely, it was my pleasure.
And I guess we'll go from the food, we'll go back to the law. But, you know, when we talk about divorce, you said that there are some things you really want people to think about before they come to see you or to see an attorney.
Right.
And what would you suggest?
I think people have to assess two things. One, the emotional, which is huge. You have to really it's a long, hard decision and not reaction. And I think people in a bad fight react, go, that's it. We're going to take off and I'm going to get divorced. And I think people then think about it and don't want it. So counseling is really important to deal with the emotional side. And the second piece is financial. And many people are not as well versed in the finances of their marriage. They really need to look at their last 3 years' tax returns, have a list of their assets and debts, a list of their expenses. What do they really need to go forward? And people don't think about all of that.
You
They
just can't do a knee-jerk reaction.
Correct.
Okay. And by the way, now she talks like a lawyer with heart, which she is, but she can be very, very tough.
Well, you definitely have a reputation. It's a good one. But I definitely heard of you before you came in today.
Okay.
Let's go to the phones. Let's start off. Let's go with Tony in Cincinnati. Tony, you had a dissolution, but your name is still on the mortgage.
Yes.
Okay, tell us your question then.
Well, in the dissolution, actually, it's pretty simple, except for the fact that it doesn't explain to you the process of when one party leaves the property to the other party, what's the ramifications and how do you get your name off the home itself.
Can he do that?
Well, there are two different pieces to the question. First of all, real estate has two parts: a debt piece, which would be the mortgage instrument, and then a deed piece, which is the title. So generally, those issues are taken care of in the separation agreement, which is attached to a dissolution, and how to deal with removal of parties' names from the mortgage and the debt document, and how to remove them from the real estate, the title part, the deed. Generally, one is a quitclaim deed, and generally on a mortgage is a refinancing to remove parties' names from the documents.
And if they can't get refinanced, the bank has no obligation to let anybody off the contract ever. Is that right?
That is absolutely correct.
So what a divorce court can't do is make a bank release a creditor.
No, it can only deal with the parties themselves,
Yeah.
unless the bank is a party. That goes back to the old Constitution, you know, unless you're a party in the divorce, and usually there are three parties to a divorce: husband, wife, and the state of Ohio, but not a bank, not a school, not anybody else.
So if your spouse fails to make payments and they're supposed to, then that can mess up your credit because you're still on there and you don't even have the property anymore.
That is correct, but the court can also get involved at that point through contempt proceedings to enforce one of the parties to do what they're supposed to do.
Okay. Let's move on. We have Kathy in Western Hills. Kathy, you had a question about alimony?
Yes.
Okay, go ahead. All I heard was alimony, so if you can kind of give us a better idea of
Okay.
why you're calling.
Yes, I was married for 15 years. My husband got up and left me. I've moved 9 times. I received disability. I just can't afford it.
Okay, so if I understand, basically you want to know if there can be an adjustment to alimony. Is that your question?
Sir.
Okay, Randy?
Have you been divorced?
No, I'm not divorced.
Okay, first of all, the court has to be involved in a divorce proceeding to do anything. And alimony is one of those things, not only here, but in the state of Kentucky, to which there are no guidelines at the moment. It's been a long battle in Ohio to try and get a guideline, if anybody cares about the history. It's been the Bar Association, the judges, and the state all kind of conflicting about taking away discretion from the court and yet trying to set some guidelines for people to understand. There is no guideline in the state of Ohio. There are about 15 states in the country right now with some sort of, quote, guideline for alimony. So while there's a guideline for child support, there is no guideline for spousal support or alimony in Ohio. So until the court can get involved, the court will not, you don't get alimony. And then the court reviews a series of about 13 to 18 factors of whether there should be spousal support or not. So those factors are set forth in the Ohio Revised Code, but it's all very much discretionary.
Okay, and one of the things that she mentioned a moment ago is that she was disabled, and that is a factor in alimony, isn't it?
The health and emotional conditions of the parties is, not the, quote, disability. You don't have to be disabled to get it. The court will look at your health, your education, your emotional condition, your ability to work, your assets, and a series of other factors.
Okay, and alimony is kind of an old school term, right?
Yeah, in Ohio it's now called spousal support.
Yeah, that's what
but
I
we
thought.
all, but the IRS calls it alimony.
It's the same difference, right?
No distinction.
Okay.
And as we're talking about financial things like alimony, spousal support, if somebody comes to see a divorce attorney, what can they expect to pay? I imagine there's quite a range.
First, let's talk first. When you make an appointment with an attorney, you need to be prepared for that meeting. And those are the records, the tax returns, what your assets are. So the attorney can give you an educated advice. And that advice will probably be charged at a consultation fee. So you need to be prepared to pay a consultation fee. The second question that comes in is, what's the range the attorney's going to have? And there's going to be a retainer agreement signed, and it will set forth the hourly rate that can vary from anywhere from probably $175 to $600 an hour. And then it's a variety of other factors, and usually there's a retainer, which is a prepayment of a certain number of hours. And then it'll be billed as it goes. So it's an expensive proceeding, and there's nothing, you know, when you think about the complications involved when you're talking about children and dollars and cents in your future, it's why it's expensive.
Right. Okay. All right, we will take a break right now. We'll come back talking about divorce and child custody. Give us a call, 513-421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
Time now for your More Law Connection, where attorney Dan Moore is answering viewer emails. Good morning, Dan.
Hey, Deb, thanks a lot. Our first question today is from Mary. She wants to know, as a parent, am I financially responsible for vandalism done by my teenager? This is an interesting question because if you're talking about negligence, for example, if your teenager gets in a car crash, the parent's not responsible for the negligent acts of the kids generally. However, when we're talking vandalism, we're not talking about negligence. We're talking about an intentional criminal act. The law in both Ohio and Kentucky says that the parent's going to be responsible for the damages caused. There is a max limit, though. In Kentucky, you're responsible as a parent for up to $10,000 worth of damages. In Ohio, you're responsible for up to $15,000. So another reason to keep an eye on your kids as they get older. Deb, make sure and watch your kids.
I'm keeping my kids locked up then, Dan. Thank you. We are back talking about divorce and child custody. Randy Block, our guest today. Thanks again for being here.
Thank you.
All right, and we want to get right back to the phones now. Let's see. Let's start with Richard in Mount Healthy. Good morning, Richard.
Good morning. How y'all doing today?
Fine. How are you?
I'm fine.
Good.
I have a question. I have a friend that was married approximately about 10 years, and they weren't living together after the last age, I guess. And my friend's wife had got to an injury at work and was home from work for about 2 or 3 years. And then all of a sudden, she wants to get a divorce now, and have signed some papers for divorce. And I'm thinking that she might have got compensated or something like that, and and had divorced to where he wasn't getting anything because all he got is a paper saying that they're divorced now. And I'm trying to find out if there's any way that he can find out about that.
Well, actually, that's not a hard question, Richard. From once a person is divorced, they are a stranger to each other legally. So he has no entitlement to things that she gets after the divorce. That's the general rule. There can be an exception. The exception would be if she hid assets, which might be a personal injury action or something, that was viable and occurred during the course of the marriage. So basically, if it's for sure a marital asset, then they can go back and probably get some relief from the court. If it's not a marital asset and she gets some money from whatever source after the divorce, he's got no entitlement to it, period.
But that's not the case with child support, right? If somebody comes in, I don't know, you get a better job or you're making more money, then the child support can be amended, though.
Child support, Randy can address this better, but child support's an ongoing obligation, and that changes based on the changes in the conditions of the parties and changes in the needs of the child. So that's something that the court retains jurisdiction over until I believe the child's an adult.
18 or completion of high school generally.
Okay, good.
Right.
Okay, let's go to Rachel in Indiana now. Rachel, you have a question about shared parenting.
I do. Our divorce was final in December 2010. We live in Indiana, and I have full physical custody with shared parenting, and I'd like to know how I go about leaving the state of Indiana and changing the parenting time, and if I have to retain my attorney to do so.
I don't know Indiana law, but generally the law in all 3 states, Kentucky, Ohio, and Indiana, are pretty much the same, that the court maintains jurisdiction over children, as like you talked about with child support. So that you have the situation where you can go back to the court and request the court for permission to leave the jurisdiction, and it's up to the court to grant that motion favorably or not favorably, or make modifications in the parenting plan. A lot depends on how far you're going to go,
Right.
What's the reason you're going, what impact is it going to have on the children.
Okay, all right, let's head back to Dan Moore with another email question. Dan?
Okay, our second question is from Damien. He says, my tenant will not allow me access to my rental property to repair a dishwasher. Instead, she said she just wants money to buy a new one. What can I do? Well, she's not allowed to do that. As a tenant, you cannot restrict your landlord's access to the property. In Ohio, what you can do is just send a notice out saying that you're going to be in the property in 24 hours, and you go and perform the work that you need to perform. In Kentucky, you have to send a notice saying you're going to be there in 2 days, and you go in, do what you need to do. If the tenant, for some reason, has changed the locks or otherwise restricted your access so that you can't get in, then what you can do is go to court and get a court order having the court tell the person that you have access to the property and you can go in and do what you need to do. The other option is to evict the person. Bottom line, though, is they just can't do this. They cannot prevent you from going in and fixing the property that you want to fix. And then on top of that, they're not allowed to dictate what you do, replacing the dishwasher versus fixing it. So as always, if you have a question, go to the fox19.com website, click on the More Law link, fill out the form there and send it in to us, and we will do our best to answer your questions. Deb, back to you.
All right, thanks a lot, Dan. We're going to take a break right now. We will be back with more law. Give us a call, 513-421-4691.